All right, good morning. Welcome to the 4th annual U.S. Space Command Legal Conference. My name is Jeff Biller. I'm the Deputy Director of the Academy's Law, Technology, and Warfare Research Cell, and I will be your conference host. As always, my primary job here is to just keep this train moving on time. First off, let me say how wonderful it is to see all of you here in the 4th year of our conference. I see a lot of repeat performers out there, so welcome back. One of the great things about this conference is getting this community of space professionals together on an annual basis and being able to catch up and share where we're all at. It's our sincere hope that the relationships made here will strengthen the space enterprise and enable domestic and international cooperation. Having said that, we realize that not everybody was able to make it here in person, so welcome also to those of you who are participating online. As the conference proceeds, we'll make every effort to get to as many questions both in audience and online as we're able to, but with so many different people attending, please be aware that we may not be able to get to everybody's questions. This year's theme is Space Futures, the legal implications of space operations in GEO and beyond. Activities in space have accelerated dramatically in the past decade and show no signs of slowing. As legal professionals, it's vital that we not only consider and address current issues, but anticipate the legal issues related to future space operations that will need to be addressed. This conference seeks to build on existing efforts to identify and address those future problem sets. Before we jump into the official opening remarks, there's a few administrative matters I need to cover. First, let me introduce the members of the conference team. These are the individuals. If you have any questions about the conference, please address it to one of those. First off, we have Professor Aubrey Davis, who is our conference director. Right next to him, we have Lieutenant Colonel Tim Goins, the director of the Law, Technology, and Warfare Research Center. He'll be running the online portion of the conference. We have Major Trent Bradford from the Department of Law. I'm looking for Major Matt Ormsby. He is in the back right there. He is the conference co-director. We also have Miss Madison Walker, the Space Policy Fellow at USAFA's Institute for Future Conflict. And additionally, we have several members from the Space Command Office of the Staff Judge Advocate. We have Major Jonathan Sawmiller right over there on the side, Major Sandra Ahinga, and Melissa Murphy, who will be directing, those three of them will be directing the classified third day of the conference. Right now, if you have a green dot on your name tag, I see everybody looking down, that means you have not yet gotten all the information as to your security clearance. So if you could see one of the members of the Space Command team to make sure that you get everything that you need for them for the classified third day of the conference, we'd very much appreciate that. Additionally, if you see our cadets in their blue uniforms, they can assist you with anything that you might need in terms of questions or directions. Next, a couple safety considerations. If there is a fire alarm or if there's any other reason we need to evacuate the conference center, please exit through the back of the conference center and then through Arnold Hall the way that you came in and out to the parking lot. So that parking lot out in front of Arnold Hall where you all filtered in through, that'll be the collection point if we do have a fire alarm or need to evacuate. For those not used to the altitude, if you're coming in from out of town, we do highly recommend that you continue to drink water. That can help maybe stave off a headache that some people get when they experience. We are at 7,000 feet here at the conference center. Having said that, the bathrooms are located behind me. There's on that side of the conference center. Additionally, if during the breaks, those bathrooms get fairly full, there's also much larger bathrooms in Arnold Hall. So if you just, again, go out through the back and right through into Arnold Hall, there's much larger restrooms right back through there. All right, for those of you interested in CLE for the conference, there's a sign up in the back of the conference center. Following the conference, we'll be sending out a packet with all the information that you need to file with your state bar associations. The Wi-Fi, if you haven't had a chance, the QR code was up earlier. The password for the Polaris Hall Wi-Fi is North Star, all one word, capital N, capital S. There's also a USAFA.net connection that has no password for it. If for any reason you desire to head over to the cadet area, please note that you have to be accompanied by a permanent party member here who has their badge. Even if you're a DOD ID card holder, you can't access the cadet area. So if for any reason you do need to go over there, just ask one of the conference organizers, please. As we go through the conference, during the breaks, we'll always provide a 5 and 1 minute warning prior to rejoining after the breaks. Additionally, things move fairly quickly in space, and the same is true with our conference here. As a result, I'll be providing fairly brief bio introductions for our speakers today. Part of the reason is we have made those wonderful bio books. They're available in the back. You can also get them digitally with the QR code on some of the signs that are located throughout the conference center. So it's not intended to diminish anybody's long and distinguished career. We just want to make sure that we have plenty of time for our speakers. Along those lines, please keep in mind that unless otherwise indicated, the presentations or comments of all speakers here today are their personal opinions and do not necessarily represent the opinions of the U.S. government, the Department of Defense, the military service, Space Command, the Air Force Academy, their speakers organization, or even their own opinion by the time they finish speaking today. We are not operating under the Chatham House rule, but however, this is intended to be a forum for open discussion and to explore new ideas. At the conclusion of both today and tomorrow, there will be a no-host happy hour at the Cadet Lounge here at the Academy called HAPS. So if you would like to socialize with us at the conclusion of today and tomorrow, again, we'll have signs up and the cadets can point you in the right direction, but just proceed again out through the back and into Arnold Hall, and then we can point you towards HAPS at the end of the day. We'll be staying there starting about at 16:30 at the conclusion and going to approximately 1800. For lunch options today, in Arnold Hall, there is a small food court with 3 or 4 different options. There's a Subway, there's a Mediterranean Grill, there's a Domino's. We're also going to have a couple food trucks that come out. I believe today we have Banditos, which is Mexican food, as well as a B-52, which is like a burger truck. So those will be located just outside of our Arnold Hall in the parking lot there. And finally, please join me in thanking the University of Mississippi School of Law and their Center for Air and Space Law for providing this morning's refreshments. This morning we'll have refreshments provided by McGill University and tomorrow from the University in Nebraska College of Law. We are very happy to be able to partner with those amazing institutions to make this a successful event. Okay, now that I've covered those administrative items, I'd like to turn it over to the lead of your organizers' institutions, Brigadier General Linnell Latendra, USAFA's Dean of Faculty, and Colonel Robert Hall, the Space Command Staff Judge Advocate, for opening remarks.
Thanks, Professor Biller. I really appreciate it. And welcome to the United States Air Force Academy. We are so excited to have each and every one of you here. And I know many of you are repeat customers, but you may be wondering, why a USSPACECOM USAFA hosted event? It's not just because we happen to be in the same geographic location. In reality, this collaboration, I think, brings together the best of all worlds. It brings together the operations side of space law, along with some of the foremost minds in academia in thinking about this. The other reason I'm excited that it remains a partnership here is because you'll also see some fairly young faces in some cadet service dress in the back. Hosting something here allows us to engage with the individuals who are going to be actually operating and thinking and moving our space forward. We believe USAFA should be the intellectual home of the Space Force, not just with respect to STEM, but across history and law, our humanities and social sciences. And by engaging with you all in this space, we help to further that reputation and further the research and the thought that is being done here. I'd like to also thank the many people who have come from afar. Honorable Caroline, thank you so much for being here and kicking things off for us today. I think all of you are going to be amazed by not only the insightful panels and the speakers that we have today, but hopefully the dialogue that you also engage in between these panels and discussions. And before I hand it over to my collaborator in chief, we ran through a whole bunch of names earlier, and they were highlighted as people you can go to for help. And that is true, but I'd like all of you to stand back up again, both from the United States Air Force Academy, as well as from USSPACECOM. These are also the people we need to thank. Thank you so much for putting this on and doing all the work to make this possible. And so with that, I hope you enjoy our beautiful spaces here at the United States Air Force Academy, and I will hand it over to our main collaborator in chief, the United States Space Command Legal Counsel. Bobby? You're welcome.
Good morning, everyone. I have to admit, I'm having trouble finding people in the crowd that I don't know. So it's almost like we're having a meeting at our office. It's just a little bit larger than usual. Welcome here, as everyone said so far. It's a beautiful location, a beautiful facility, and great synergy between the Academy and SpaceCom for an event like this. You're going to see on the agenda, there's a packed program here. So things are going to move fast, and there'll be a lot of speakers. And what I want everyone to know is the conversation only begins with the presentations you're going to see today and the panels you'll see today. We have some healthy breaks built into the schedule for multiple reasons, but we also have some places set up where you can collaborate more closely. So along the east side here, we have some collaboration rooms that correspond to the panels that you'll hear today. So if you want to talk more about that subject, you and whoever else wants to talk about it, including panel members and moderators, can go in the corresponding room. Along the west side, on the back corner there, is the SpaceCom legal kind of ops center, if you will. And so if there's anything in particular you're trying to find or you need, we can help you out there. And Melissa Murphy, I can see her back there. She's ready to help. Right next to that, we have a room for our international folks. And I want to put a special welcome out to our international attendees this year and panel members. So we have Air Vice Marshal Jennings is here once again from the RAF. Thank you very much for being here, ma'am. And we have countries that are in the Combined Space Operations Initiative. All 10 countries are represented here. So we have a room there for them to put their bags down and to collaborate as well. And I think some of them are already here sitting up there. I did hear there was a traffic problem coming in the south gate. I'm not sure if anybody else ran into that, but people will filter in as the conference gets off the ground here. So welcome to all of you for being here today. And what you'll hear from the very beginning, from when Honorable Krass comes up here and speaks in just a few minutes, all the way through to General Whiting speaking tomorrow, our commander, you'll hear about the challenges we're facing today in the space operations environment and how those connect to the legal mission. The challenges that we have today are going to persist, and we're going to keep working on them, particularly from GEO inward. There's, as you all know, it is congested and contested, and we will continue to operate there, and we'll solve legal problems there. But what we wanted to do at the conference this year is to deliberately kind of lift our head up a little bit farther, sort of like lifting up to that circle at the top. If you didn't know, it's aimed right at Polaris. If you stand in the right spot, you can see the North Star at the right time of day. We wanted to lift our heads up a little bit farther and look at the operations that are heading from GEO out. At an unprecedented level, there are private and government entities sending stuff to and toward the moon. And they have a lot of aims that go beyond that as well. As you all know, that's territory that hasn't been tread that much by humanity. But it will be a lot in the future, especially the way that the commercial industry has stepped up the pace for everyone to reach out there and explore and to capture resources if they're available. So what we want to do is have the content focused on that as well, in addition to the challenges we're facing today. So that future, because it's accelerating so quickly in the past few years, that future is coming quickly, and the future inside the government, particularly the military, is going to depend a lot on those cadets that you see around here. They're the leaders of tomorrow for the space mission. It's going to depend a lot on the majors you see from the SPACECOM team, as well as the broader space enterprise, the 04 level officers in the military. It's going to depend a lot on them to be the colonels and generals in the future leading the space mission and advising commanders on that space mission. So what you'll see is a lot of the panels are led by those majors who practice space law every single day. And I encourage you all to get to know them, engage with them in between. They know a lot about what's going on and how to apply the law to what we're actually doing in operations. So with that, we do have a lot of content to move on to. I'm happy to talk to any of you as well. But right now, what I'll do is I'll hand it back to Mr. Biller so he can introduce Honorable Krass, the Department of Defense General Counsel. Thanks.
Great. It's now time for our first keynote presentation of the conference, The Practice of Law and the National Security Space Enterprise. Providing this presentation will be the Honorable Caroline Krass, the General Counsel of the United States Department of Defense. Ms. Krass serves as the Chief Legal Officer to the DOD and the Principal Legal Advisor to the Secretary of Defense. She has authority and responsibility for legal policy and determinations across the Department of Defense and its components. She has received multiple awards and honors, including the CIA Distinguished Intelligence Medal and the CIA Director's Award, the John Marshall Award, the highest Department of Justice award for an attorney, and the Department of Defense Medal for Outstanding Service, as well as the Department of State Superior Honor Award. Ms. Krass, thank you very much for joining us.
Good morning, everybody. I want to thank General Whiting, Brigadier General Latondra, and Colonel Hall for inviting me to speak at USSPACECOM Command Legal Conference today. And I'll just say that, notwithstanding the remarks at the very beginning, these are official remarks of the Defense Department, and they are fully interagency cleared. And so I want to thank any of our interagency colleagues who helped with that process, and also to my tremendous team for putting together these remarks. I'm absolutely thrilled to be here. What a gorgeous facility, which so symbolizes the importance of space law and the Air Force and the Air Force Academy. Bringing the legal community together to discuss the legal and policy aspects of space operations is a critical component to the effective implementation of the law. Space offers a fascinating lens through which to consider the practice of national security law, in which each of us here and those also on the screen are fortunate to engage every day. There's no doubt that space law is truly cutting edge. We can all see that space is rapidly evolving with an ever-growing number and variety of actors, governmental and commercial, and increasingly strong connections across the public and private sectors. President Biden explained in the 2022 National Security Strategy that we live in a decisive decade, one marked by dramatic changes in technology, geopolitics, economics, and the environment. That observation applies with equal force in outer space as it does here on Earth. Indeed, much of our current technological revolution relies on our space capabilities. As the National Security Strategy affirms, all of humanity benefits from the continued and increasing exploration and use of space, whether through the opening of new economic opportunities or the development of novel technologies, or an enhanced ability to monitor the climate. With these exciting advances comes an increasing need to protect our interests in space. The National Security Strategy articulates a four-part framework for safeguarding U.S. interests while avoiding destabilizing arms races and responsibly taking care of the space environment. First, the United States will continue to be the world's leader in space and work together with the international community to ensure the domain's sustainability, safety, stability, and security. Second, we're at the forefront of updating governance mechanisms for outer space, including by establishing a space traffic coordination system and charting a path for future space norms and arms control. Third, the United States is working closely with our allies and partners to develop policies and regulations that pave the way for the growing U.S. commercial space sector to compete internationally. And finally, the U.S. is enhancing the resilience of U.S. space systems that we rely on for our national defense and intelligence collection. And just by way of remark, I won those awards at the CI because I worked there, in case you're wondering. Just as the use of space involves a variety of actors and activities, so the practice of space law involves engagement across many sectors and the harnessing of a range of tools to implement the law and develop best practices. Before I speak in more detail about several specific space issues, I want to highlight two overarching themes. First, the broad and diverse legal issues relating to space operations are integral to DoD's efforts to promoting the rules-based international order. And second, the practice of space law is in effect multi-domain lawyering. The law is an integral part of achieving the strategic objectives set forth in the National Security Strategy. One of my key priorities as the General Counsel is ensuring not only that we follow the rule of law in our own work, but also that we as a department promote that rule of law around the world. From the Secretary and the Chairman of the Joint Chiefs on down, our clients fully embrace the importance of adhering to US and international legal obligations. Indeed, a crucial plank of the 2022 National Defense Strategy, as in the National Security Strategy, is the promotion of a rules-based international order. International law is the framework that states have adopted to set binding standards for their behavior, serving as an essential pillar of stability in the international system. All of us, and DoD lawyers specifically, have a profound obligation to ensure that the department's many activities are conducted consistent with all applicable domestic and international law. Those activities increasingly include space operations in support of a variety of mission areas, such as space domain awareness, positioning, navigation and timing, intelligence, surveillance, and reconnaissance, and satellite communications. The multifaceted nature of space operations, as well as operations across other domains that touch or rely upon space capabilities, demands that we analyze, apply, and implement the law with an understanding of the interconnectedness at play. And that brings me to my second theme. Not only is space a linchpin of multi-domain operations, but the practice of law with respect to space operations is multi-domain lawyering. By nature, space operations, space capabilities, and space developments occur across multiple sectors: public and private, civil and military, domestic and international, departmental and interagency. One might say that very little in space happens in a vacuum. In the same way, multi-domain lawyering cannot be carried out by individual lawyers acting in silos. Space thus demands a legal practice that is nimble, cross-cutting, and able to thrive in a world of coordination. Indeed, providing timely legal advice on space issues invariably involves leveraging a network of experts from across DoD and the interagency legal community, often including consultations with foreign partners and commercial entities as well. Fostering those deep interdepartmental and external relationships is one of the things that I have seen DoD lawyers do best. Lawyers for space operations do not simply advise their clients on what is permissible under the Outer Space Treaty. They do that, to be sure. But they also advise on the drafting, negotiation, and interpretation of agreements with partner nations that allow for the installation of ground stations, on the plans and orders that the joint force develops to integrate space capabilities with terrestrial activities, on the procurement activities and test and evaluation programs that preserve U.S. leadership in space technology, and on the personnel and organizational policies that transform talented individuals into high-performing teams. This truly is multi-domain lawyering, and lawyers who work in this area are trusted by our clients. I appreciate how hard each of you works to maintain that trust. Consider some of the goals set forth in DoD's recent 2023 National Defense Science and Technology Strategy and how they relate to space. That strategy calls for us to work through bilateral and multilateral channels to strengthen our science and technology defense cooperation with allies and partners, and to create new science and technology partnerships with countries that share our values, that innovate to create new technologies, and that are committed to protecting technologies from competitors who seek to erode our advantages. The strategy also emphasizes the importance of finding new ways to take advantage of dual-use technologies that solve national security problems, such as by promoting interconnectivity within the innovation ecosystem and taking advantage of the innovative work of the U.S. small business community. Our legal advice to clients on the development, design, and maintenance of such initiatives across the varied sectors of the space arena involves multi-domain lawyering. I see huge value in lawyers being involved in these initiatives from the very beginning to help shape them consistent with applicable law. As we think about the rapid evolution of the space domain and all that comes with it, it is important to remember that although space presents a steady array of fascinating legal issues of seemingly first impression, we already have an extensive body of international law, as well as a growing body of domestic law that are often directly applicable, and if not directly applicable, provide useful guidance. Our clients with technical expertise would not approach the development of a new capability for a national security space purpose as an entirely new problem. But instead, they would tackle that project by leveraging existing tools and lessons learned from developing and acquiring other systems and technologies. We lawyers should, and we do, bring the same approach to space law issues. Lawyering in the space arena therefore requires not only the application of existing space law and other applicable international and domestic law, but also, where relevant, the nuanced incorporations of lessons from the practice of law in all other domains. At the same time, we have to be careful to avoid the reliance on imperfect analogies, such as from the law of sea or air law, especially when we have legal rules that are unique to the space domain. I'll discuss this in greater detail in a few more minutes. The two themes that are at work, the promotion of the rules-based international order and the idea of multi-domain lawyering, play out across the practice of space law. In our remaining time together today, I'd like to showcase 4 areas that illustrate these themes. First, working with allies and partners. Second, the development of norms and policy that build on core elements of international law. Third, engagement with the commercial industry. And fourth, collaborating with the interagency legal community. Our engagements with allies and partners are essential to promoting and strengthening the rule of law, particularly in contested and rapidly evolving space domain. It is imperative that we continue to work with our allies and partners, as we have for more than half a century, to reinforce the core principles set out in the Outer Space Treaty. For example, we must reemphasize the ironclad international consensus regarding the danger of and the prohibition against the placement of nuclear weapons or other weapons of mass destruction in outer space. Such prohibitions help us safeguard the free use and exploration of outer space for all. At a more operational level, working with our allies and partners offers us tremendous advantages, such as our collaboration in operating the SPACECOM Joint Commercial Operations Cell. JCO, which is managed here in Colorado by the National Space Defense Center, enables the development of space domain awareness entirely from commercial sources, facilitating the sharing of data and products with allies and partners because the information is not based on classified collection. Ally and partner-led regional JCO cells in Europe and the Indo-Pacific region add depth and resilience to the capability, transferring management of the JCO mission from cell to cell around the globe in 8-hour shifts for a comprehensive 24-hour coverage. Another example is the Combined Space Operations Initiative, or CSPO, a multinational partnership with a mission to generate and improve cooperation, coordination, and interoperability to sustain freedom of action in space, optimize resources, enhance mission assurance and resilience, and deter conflict. In December 2023, defense representatives from Australia, Canada, France, Germany, New Zealand, and the United Kingdom, as well as the United States, welcomed 3 new partners to the CSPO initiative from Italy, Japan, and Norway. I understand that there are representatives from all of these CSPO partner nations today, many of whom are here in person, and I wish you a warm welcome. These value-based alliances and partnerships are a significant advantage for the United States, essential to demonstrating our shared values and commitment to the rule of law. As in other domains, developing consensus, or at least common understandings across different countries' legal systems requires hard work. There's much that we agree on, of course, but even when we occasionally have different interpretations of particular legal rules, it is important to be aware of and to understand such differences, and to continue to collaborate and engage in conversation. One challenge we have in engagements with allies and partners is the classified nature of much of the information related to space operations. Collaborating with our allies and partners requires us to navigate each other's security rules, which can be more complicated when our classification standards are not in sync with our operational needs. Ensuring operational alignment with our allies and partners was a key reason that the Defense Department led a comprehensive review of classification for space capabilities, culminating in an updated policy issued in January of this year by the Deputy Secretary of Defense. This new space classification policy lowers the minimum level of classification for various types of space activities, which will allow for greater sharing of information, not only within the United States government, but also with our allies and partners. Part of our work with allies, partners, and the international community as a whole involves the development of voluntary norms, best practices, and guidelines that are not legally binding, but can play an important role in guiding and influencing state behavior. Such norms may be the most attractive option when, as now, competition and conflict result in a geopolitical environment that is not conducive to developing new legally binding obligations. Voluntary norms are also appropriate in the context of rapid ongoing technological advancement, so to avoid inadvertently hindering the development and use of novel technologies. Such best practices, guidelines, and norms allows us to identify and address behaviors that have the potential to lead to miscalculation and misunderstanding, and thereby to mitigate the risk of inadvertently causing a conflict or a degradation of the outer space environment. The U.S. government has recently taken or proposed several actions to promote such norms in both the international and domestic arenas. From an international perspective, in April of 2022, Vice President Harris announced a new U.S. commitment not to conduct destructive direct ascent anti-satellite missile testing, an important example of U.S. leadership. The Vice President called on other nations to make similar commitments and to work together to establish this commitment as a norm, explaining that it would benefit all nations. Just a few months later, in December of 2022, the United Nations General Assembly overwhelmingly adopted, in a vote of 155-9, a resolution calling upon all states to commit not to conduct destructive direct ascent anti-satellite missile tests. I challenge you to say that 10 times fast. The resolution further affirmed that such a commitment is an urgent initial measure to prevent damage to the space environment and to help to avoid an arms race in outer space. To date, 37 states, including Canada, Germany, Japan, and New Zealand, who all have representatives here today, have made this commitment. These commitments by states across the globe, from Europe, including the European Union as a whole, to the Indo-Pacific region, with Norway and Costa Rica as the most recent, contribute to the establishment of a recognized norm of responsible behavior. Unfortunately, other nations have recently conducted destructive direct ascent anti-satellite missile tests, notably China, Russia, and India. And those states either voted against or abstained from voting on the General Assembly resolution. Clearly, we still have more work to do, and we will continue to seek to advance additional norms of responsible behavior in space multilaterally. Two domestic developments showcase the U.S. government's, and in particular the Defense Department's, efforts to promote responsible norms that build on core elements of international space law. The first, in July 2021, Secretary Austin set out the tenets of responsible behavior in space for all DoD components. This memorialization of longstanding military practices in the space environment enhances clarity and predictability for space operations. U.S. Space Command elaborated on these tenets by proposing, perhaps with the involvement of many of those in the room here today, 8 specific behaviors for how to implement Secretary Austin's 5 tenets. The Secretary approved these 8 behaviors in February of 2023. The tenets of responsible behavior and the 8 associated specific behaviors draw from principles reflected in space law and best practices for space sustainability. Consistent with the 5 tenets, DoD components will first operate in, from, to, and through space with due regard for others and in a professional manner. Second, limit the generation of long-lived debris. Third, avoid the creation of harmful interference. Fourth, maintain safe separation and safe trajectory. And fifth, communicate and make notifications to enhance the safety and stability of the space domain. The tenets are directives to DOD components, but can also serve as a starting point for conversations with the international community about norms. The tenets reflect the importance of two pillars of space law. First, due regard for the corresponding interests of all other states parties to the Outer Space Treaty. And second, avoiding harmful interference with the peaceful space activities of other states parties through efforts such as notices, communications, and consultation. As we've explained in multilateral fora, the US government believes that due regard means that acting in a safe and professional manner in outer space entails taking into account the corresponding interests of other operators, much like operations in air and at sea. A practical set of common guidelines and standards for actions that can be taken to avoid impeding other space operations can help to create a more orderly and predictable space environment for all, allowing space operators to avoid unnecessary maneuvers and other activities that could arise from confusion about another's plans and intentions. Efforts to avoid harmful interference, particularly with respect to strategic systems of other states during peacetime, can similarly help to avoid misperceptions and misperceptions regarding a state's intentions. For example, states could view interference with certain space objects, such as those designed to support treaty compliance monitoring, command control, and communications of nuclear forces, or missile strike warning, as a precursor to other, more escalatory activities. In addition, harmful interference with space-based services that can constitute or support critical infrastructure, such as global navigation satellite services, could have widespread impacts on society. Working to identify responsible behaviors, both in our domestic policy and in our multilateral engagements, will help in developing voluntary, non-legally binding norms that address how to operate safely in outer space, consistent with existing international law. Although the development of detailed legally binding rules defining responsible behavior in space is challenging, the US government has taken the initiative to enhance transparency and promote consensus on responsible behavior. The second major effort by the US government to develop norms and policies to promote responsible behavior concerns state responsibility with respect to commercial space activities. The White House recently issued the United States Novel Space Activities Authorization and Space Framework, an accompanying legislative proposal. I'll give some background before saying more about these recent initiatives. State responsibility refers to the responsibility that a state bears for its own conduct and for conduct attributable to the state under international law. Under customary international law, a state bears responsibility for its own internationally wrongful acts. But it also bears responsibility for the acts of persons or entities that are attributable to the state, including the acts of a non-state entity that is acting under the state's direction or control. The rule of attribution governs when the actions of private parties, whether a non-state party, non-state group, an individual, or a commercial entity, are attributed to a state for the purpose of assigning responsibility for internationally wrongful acts. In space, however, implementation of state responsibility is governed by special rules of international law, with implications for the regulation and supervision of commercial activities and potential ramifications with regard to activities in situations of conflict. For example, Article 6 of the Outer Space Treaty provides that states parties to the treaty shall bear international responsibility for national activities in outer space, whether those activities are carried out by governmental agencies or non-governmental entities. This space-specific principle of state responsibility attributes responsibility to states for certain conduct by non-state actors that would not otherwise be attributable to the state. Although the Outer Space Treaty's intent to broaden the scope of state responsibility seems clear, determining the treaty's application in practice may involve a complex assessment of distinct yet interrelated treaty concepts. For example, under Article 6 of the treaty, the activities of non-governmental entities require the authorization and supervision of the appropriate state. But the phrase appropriate state is not defined. Under the Outer Space Treaty and Registration Convention, the launching state is responsible for adding a space object to its registry and for exercising jurisdiction and control over that object. But when more than one state qualifies as a launching state, those states may consult before launch and reach agreement about which state will register the object. But what if they don't? And how should the Article 6 concept of international responsibility be applied in a world where rogue, non-state actors may develop the capability to conduct activities in space without the authorization or even the knowledge of the state from which the activity is launched? Although these prospects were mere academic questions just a few years ago, rapid advances in space capabilities, such as the prospect of launches from maritime areas beyond national jurisdiction or launches from international airspace, could make them a reality. As I alluded to previously, one component of state responsibility in space law, as reflected in Article 6 of the Outer Space Treaty, is the obligation of the, quote, appropriate state party, end quote, to authorize and exercise continuing supervision over the space activities of non-governmental entities. This requirement remains a unique and critical piece of the legal architecture of space law. Here, the United States is demonstrating leadership in behaving responsibly through our efforts to update our multi-sector commercial space licensing process. Under the U.S. regulatory system as it exists now, the National Oceanic and Atmospheric Administration licenses private remote sensing activities. The Federal Aviation Administration licenses commercial launch and reentry activities and sites, and the Federal Communications Commission launches non-federal government use of the electromagnetic spectrum. Across these three U.S. licensing entities, there are clear parameters to ensure that space activities are conducted responsibly. But evolving space capabilities and activities, such as refueling in space assembly and servicing, or towing for end-of-life disposition, introduce novel and challenging questions that highlight the need for multi-domain lawyering across not only the interagency community, but also between the government and the commercial sector. These new activities require rendezvous and proximity operations, resulting in controlled physical contact between space objects. But a satellite that can touch another space object for refueling or repositioning could also be used, in theory, to damage the other object deliberately. Or, if poorly executed, the operation could result in damage to the target space object and potentially significant space debris. Navigating these types of scenarios requires careful legal analysis and an understanding of the obligation under the Outer Space Treaty for a state to authorize and exercise continuing supervision over non-governmental entities. In addition, there are potentially complex questions regarding attribution and state responsibility. Novel space activities present not just technical issues, but as I think you all appreciate, difficult legal questions. It is with an eye to these sorts of novel space activities and the questions they will raise that the administration issued its Novel Space Activities Framework and complementary legislative proposal last December. This framework and associated legislation, if it is enacted, significantly updates how the United States will accomplish its authorization and continuing supervision function. It formally defines novel space activities as those activities that are not directly regulated under the current U.S. regulatory regime for private sector space activities, including industry, academia, and nonprofit organizations. Such activities include commercial habitats, in-space manufacturing, and on-orbit refueling, among others, which are not clearly addressed by the existing licensing schemes. As Vice President Harris has explained, the administration is committed to establishing rules for commercial space activities that are strong enough to promote the safe and predictable use of space, but flexible enough to ensure that we do not stifle innovation. The Novel Space Activities Framework recognizes the importance of maintaining access to and freedom of use of outer space, as well as the importance of protecting U.S. national security and other interests. It thus seeks to position U.S. policy and systems to be adaptable to changing needs and provide a predictable, transparent, and justifiable foundation for U.S. entities to pursue their economic, intellectual, scientific, exploration, and cultural goals in space. This framework and legislative proposal represent bold and innovative thinking and demonstrate this administration's leadership in promoting the rule of law. Bringing our regulatory processes up to date to reflect current realities and capabilities will help the United States continue to be at the forefront of how a responsible spacefaring nation regulates commercial industry. At a broader level, DOD's engagement with commercial industry is a third area that illustrates my two themes of promoting the rules-based international order and multi-domain lawyering. The dramatic expansion of commercial capabilities in space provides both opportunity and risk. Commercial innovation and economies of scale promise to bring cheaper, faster, and more reliable capabilities to the space enterprise. But at the same time, the widespread availability of space capabilities will increase the number of potential security challenges and concerns for the Defense Department. For example, if the department designs its own system, we can build elaborate security measures into that system. But design and procurement take time and money, as we're all familiar. The department could alternatively use commercial systems, which are available much more quickly and at a cheaper price, but without the DoD design security measures. These are trade-offs that policymakers must consider. To keep us on the right footing as we balance these risks and opportunities, we need lawyers from both the public sector and the private sector to help ensure that advancements in space are made responsibly. Norms of responsible behavior in space must incorporate commercial space service providers. Lawyers for spacefaring organizations, including DoD, are critical to making that happen. From requirements definition through contract closeout, we ensure that our clients in DoD are implementing the tenets of responsible behavior and working with industry to do the same. Responsible behavior in space boosts the long-term financial viability of commercial capabilities. For example, consider the impact space debris could have for commercial activities. The growth and vibrancy of the commercial space industry relies on a sustainable space environment, but reckless decisions to conduct debris-producing anti-satellite missile tests can imperil that sustainability. Similarly, slow implementation of multilateral operational guidelines, such as the Space Debris Mitigation Guidelines, coordinated by the Interagency Space Debris Coordination Committee, or the United Nations Guidelines for the long-term sustainability of outer space activities, unnecessarily hinders sustainability efforts. Proliferation of debris, especially in protected environments, such as low Earth orbit, increases operating risks and complicates insurance markets for commercial space providers. As part of the government effort to enhance the sustainability of space, DoD is coordinating closely with the FAA on a proposed rule on mitigating orbital debris caused by the upper stages of launch vehicles. Lawyers across DoD and the intelligence community are also working with lawyers in the space and insurance industries to better understand ways to manage the risk debris poses for commercial space operations. As another example, we help our policy clients coordinate with the commercial space industry on the use of DoD managed airspace and the National Space Test and Training Complex. This coordination helps to provide the flexibility for launches and reentry or recovery at sea that lead to private sector innovation, while also ensuring the appropriate environments are available for our space launches, aircraft operations, naval exercises, and space test and training activities. Finally, I'd like to touch on the way that space highlights the importance of collaboration across the interagency legal community. In particular, DoD worked with the National Space Council and lawyers from the Commerce Department, the FAA, NASA, the State Department, and other agencies on the legislative proposal on novel space activities to help to ensure that, if enacted, it would provide authority to the Secretary of Commerce to develop and operate a capability to collect and disseminate space situational awareness, data, information, and services. The proposal would also, under the heading of space traffic coordination, have the Secretary of Commerce provide operational recommendations to eligible entities to ensure safety of space operations, compliance with U.S. international obligations, foreign policy interests, and other national interests of the United States. But at the same time, the proposal preserves our ability at DoD to protect national security by providing that Commerce's new authority complements the continued statutory authority provided to the Secretary of Defense to provide similar data in furtherance of the national security interests of the United States. DoD's role in providing information and services about the ever-increasing number of trackable space objects is therefore evolving. While we continue to perform our historical role in providing information to underpin the global safety of spaceflight, DoD is also supporting the Department of Commerce to transition many of these services to be integrated into Commerce's vision for space traffic coordination, a new activity. Meanwhile, DoD continues to have statutory authority to provide SSA services and information to non-government entities. To the extent that the Secretary of Defense determines such actions are necessary to meet the national security interests of the United States. The proposed legislation would help to take today's space situational awareness environment into the future. The Department of Commerce would be the government provider of SSA data for civil purposes and would be the face of the government to the commercial world for the safety of spaceflight operations. Although DoD will always need to retain SSA capability for our own operations, the transition would allow DoD to focus our efforts on space domain awareness, that is, efforts to understand and characterize activities in orbit, including potential threats for national security purposes. Taken together, this redistribution of efforts within the executive branch, aided by interagency legal collaboration, will allow for greater efficiencies and a more logical distribution of responsibility. So to circle back where I started, the rules-based international order is critical to a well-functioning world economy and to efforts to maintain peace and stability. We must continue to work to advance that order in our new space age, even against the backdrop of a geopolitical scenario that makes the negotiation and development of new treaty law challenging. The United States can advance the rules-based international order through whole-of-government norms development, such as the commitment not to conduct destructive direct ascent anti-satellite missile tests. We can promote and advance the rules-based international order as a department through conduct consistent with the tenets of responsive behavior promulgated by the Secretary and further developed by the Commander of U.S. Space Command. We can advance the rules-based order by working with our interagency partners and the private sector to help ensure appropriate regulation and oversight of novel commercial space activities. And we can even do so individually, every day in the course of our work. By supporting such efforts and through your own outstanding work, we can be effective multi-domain lawyers at the forefront of ensuring that the United States and DoD space operations are at the leading edge, both technically and legally. Thank you very much.
Thank you very much, Ms. Krass, for those valuable remarks. And please let me thank you with something that's also of tremendous value, the coveted 2024 U.S. Space Command Legal Conference coin. Thank you very much, ma'am. We very much appreciate you taking your time.